Hello and welcome to part 2 of this 3-part series talking about machine learning at the EPO. My name is Sam Jones. I'm a UK and European patent attorney at Gill Jennings Every. And in this section, we're going to talk about types of machine learning invention and how they're treated by the European Patent Office, and the types of things that you might want to think about when drafting and filing patent applications to these types of machine learning algorithm. So the EPO held an AI conference in 2018 in which types of machine learning patent that they're routinely seeing were discussed. And they very helpfully provided an indication of the different types that they're seeing. And we've been finding this very useful as it really gives a framework in which you can focus your claim drafting to make sure that you're covering the correct parts of the inventive concept. And also, it really does inform the level of detail in which you should go into describing the machine learning algorithm in a description of the patent application. So I thought I will go through the 3 types, and I've got some examples as well of granted patents for 2 of the types. So type 1 machine learning patents are core machine learning, which relate to the algorithms as such. So it could be a completely new machine learning algorithm, or it could be an algorithm that's been configured specifically so that it operates particularly well on, say, a class of GPU or something like that. And so inventions that fall into this category relate to the design of machine learning tools rather than the application of machine learning to any particular problem. So for this reason, it makes them quite difficult to protect via patents at the EPO, because as I was talking about in part 1, you need to link your machine learning algorithm to some particular technical system or operation on technical data in order to obtain technical character, which is one of the 3 things that you're going to need to get your invention patented at the EPO. And the problem with type 1 machine learning inventions is that usually they are kind of almost by definition applicable to many different technical fields, and because if you develop a new class of algorithm, you may not at the time you develop it have any idea what the end uses may be, or you may be focused on one particular end use, but it turns out that there are actually hundreds or even thousands of end uses in very diverse technical fields. So what you may find yourself falling into if you're in this category is that you either draft and file a patent application sort of solely directed to the algorithm itself, and the EPO says, yep, that looks novel, that's completely different from things that have gone before. It also seems to be non-obvious because for whatever reason, your novel features, somebody with the right technical background would not come up with them. But then they'll say, unfortunately though, this is an improvement in a mathematical method, which is non-technical, and therefore no patent can be granted, which of course can be particularly frustrating, especially when thinking about the fact that your patent application has probably been published by this point, so the information you've included in it is now in the public domain. So for type 1 machine learning inventions, you have to think very carefully about what the end uses are that you know of, and whether those end uses would be, a patent covering them would be of commercial value to you. And often you may find that in fact, it's better to keep the invention secret rather than applying for patent protection for it, because you would have to give away in your patent application too much information about how the machine learning algorithm actually works to justify filing a patent application, which may have a relatively low chance of actually being granted. So moving on to type 2 machine learning inventions. So this is where you're tailoring an existing or known algorithm for a particular use. So it could be in the configuration of the algorithm, for example, some sort of selection of hyperparameters or selection of features for a feature vector. It could be in the techniques in which you generate a training set, or it could be in the training of the model. these things can contribute to technical character of the invention as long as they support achieving a technical purpose, i.e. they are linked in some way to either control of a technical system or operation on technical data. Otherwise, if you don't make that link very, very clear in both the description and claims of your patent application, you may well get from the European Patent Office an objection of lack of technical character, which could arise. And at that point, if you don't have support in your patent application in order to redirect your claims such that they clearly do read onto something technical, you're probably going to get your patent application refused. So I've got here an example of an actual patent that falls into the type 2 category granted by the EPO. You can see that the reason that this patent has got technical character is that the claim has been limited specifically to a method for classifying an object in image data. So there you've got an explicit limitation to image data, which is considered to be technical. And so that's how you gain your technical character for this claim. And in fact, the rest of the claim, which I haven't put on the slide here because it's quite lengthy, actually just sets out details of the machine learning algorithm. So those are just mathematical method steps per se and have no technical character as far as the EPO is concerned. But that doesn't matter because the fact that the claim has been restricted to classifying an object in image data is enough. We've got all the technical character that we need at that point. And so this claim was granted. And it was granted on the basis that the machine learning algorithm classifies images more quickly and reliably than known algorithms. So, it is just a better machine learning algorithm. But if that had not been restricted to image data, and it just said a method of classifying an object in data or something equivalent, the EPO would very likely have refused that application for lacking technical character. So you can really see there that the need to explicitly limit your claim to something that the EPO can clearly recognize as technical. Moving on then to type 3 machine learning inventions. So this is where machine learning is used as a tool in an applied field, and you have to define it by way of technical effects. This is the one that we see most often. Because this is really where somebody has taken a machine learning algorithm off the shelf and used it in the context of their invention in order to provide some sort of classification or prediction or other type of output that their invention needs in order to operate. So really speaking, from the EPO's perspective, in this case, the machine learning algorithm, in fact, isn't really the invention at all. It's just a particular technique that you can use in order to generate something that the invention requires. So when we're drafting and filing patent applications to type 3 inventions, we're actually not going to focus on the machine learning algorithm much at all. It may not even appear in the claims, and we're probably only going to mention it very briefly in the description. What we are instead going to focus on is another feature of the invention, which is probably not going to be related to the machine learning algorithm at all, but which we consider to be novel and inventive. Because for type 3 inventions, you do need another feature beyond machine learning that is novel and inventive in order to give you the technical character and also the inventive step that you need to be able to have a granted patent at the EPO. And something that we need to be wary of, indeed with all types, particularly with type 3 machine learning inventions, is that we again need to make sure that the machine learning algorithm is being used in a technical context. So if your machine learning algorithm is off the shelf and you're using it for something that is non-technical, say, I don't know, making a prediction using financial data, that unfortunately, no matter how the details of the financial side of things are, because that's non-technical, that's not going to help you with inventive step. And so in that case, you have, unfortunately, a non-technical machine learning algorithm being used in a non-technical context. And so no matter how smart the other details of the invention may be, you're always going to lack technical character and you're not going to get a patent granted by the EPO. So I have here, this is an example of a type 3 machine learning patent that was granted by the EPO. And you can see there that it's directed to a monitoring system for a traffic control system. The machine learning algorithm, which is on the second indented bullet point, all it says is use of a machine learning algorithm. That's it. There's no details of the machine learning algorithm in there. And the reason for that is that's not really the invention. The machine learning algorithm is just being used to provide the ability to make a prediction on what future signal status for the traffic light system will be. So, you know, if I was drafting this claim, I would perhaps even consider not even mentioning machine learning at all, because it's not really relevant to the invention. And in this case, the inventive step was acknowledged by the EPO on the basis of the use of sensors to monitor each traffic light. So that's something that has nothing to do with the machine learning algorithm at all. And so you can see why specifying a machine learning algorithm in the claim probably isn't necessary, arguably, in this case. So that concludes this part of this talk. If you'd like any more information, please visit our website, send me an email, and I'll do my best to answer any questions you may have, or connect with me on LinkedIn.